I'll read and deal with the issues of irregularities and illegalities. And the issue we were dealing with is whether there were irregularities and illegalities committed in the conduct of the 2017 presidential election. And if the answer is in the affirmative, what was their impact, if any, on the integrity of the elections? While the impugned election was conducted in violation of the relevant constitutional principles, the same was also alleged to have been fraught with irregularities and illegalities that rendered the result unverifiable and thus indeterminate. Illegalities refer to breach of the substance of specific law, while irregularities denote violation of specific regulations and administrative arrangements put in place. The petitioners, in that context, claim that the 8th August 2017 presidential election was conducted in an environment characterized by many systematic and systemic irregularities and illegalities that fundamentally compromised the integrity of the election, contrary to the principles laid down in the Constitution. The alleged irregularities and illegalities ranged from blatant non-compliance with the law to infractions of procedure, some of which were requirements by the laws and regulations relating to the election, while others had been put in place by the first respondent for the management of the elections. Illegalities. Allegations of undue influence, bribery, and voter intimidation. In addressing the above issue, at paragraph 37 of his supporting affidavit, Raila Odinga deposed that the third respondent, President Uhuru Kenyatta, brazenly violated Section 14 of the Elections Act. He must have meant Section 14 of the Elections Offences Act by inadvertently and by advertising and publishing in the print and electronic media as well as on billboards achievements of his government contrary to that section. We have quoted the section, I don't have to read it. This prohibition is clearly what Article 81E2 refers to as improper influence. In our view, the rationale behind this prohibition in the context of this case is that whatever achievements the current government may have made resulting from expenditure of public funds should not be taken advantage of by the government as a campaign tool. Section 14(1) and the subsection 2 of the Elections Offences Act provide that except as authorized under this act or any other written law, a candidate referendum committee or other person shall not use public resources for the purposes of campaigning during an election or a referendum. Subsection 2, no government shall publish any advertisements or achievements of respective government either in the print media, electronic media, or by way of banners or hoardings in public places during the election period, end of quote. In response to these allegations of improper influence and misuse of public resources, the third respondent submitted that the petitioners had not adduced evidence showing that the particulars of such a sponsorship and that in any case, it is the mandate of the Presidential Delivery Unit to enhance accountability of a government to its citizens by availing information relating to the ongoing projects. We note in the above regard that the first petitioner has not attached any material evidence to support his proposition. That being the case, we are unable to make any determination on this issue of lack of material particulars. Furthermore, the third respondent submitted that the question whether he was allegedly sponsoring the advertisement of the government's achievement in the print and electronic media is pending at the High Court in the case of Apollo Mboya versus the Attorney General and others, and Jack Munjalo and others versus the Attorney General under the Independent Electoral and Boundaries Commission. The petitioners did not contest this averment, and in this regard, we have previously held that we can not adjudicate on an issue which is still the subject matter of judicial determination at the High Court. Reference in this respect is made to the advisory opinion this court gave in the case of, in the matter of Independent Electoral and Boundaries Commission in 2011. I don't have to read that, the quotation which states that the Supreme Court cannot adjudicate on a matter which is square and pending before the High Court. Further to the above finding, we also note that the petitioner's further contention that the first respondent failed to act on the third respondent's alleged violation of the law by his misuse of public resources. In response, the second respondent stated that he wrote a letter on the 21st of June 2017 informing the Director of Public Prosecutions about the alleged misconduct of the third respondent. The said letter is attached to the affidavit sworn by Wafula Chebukati, the details of which letter we have quoted. We note further that from considering the contents of the above letter, and contrary to the submissions by the first and second respondents, the above letter did not apply to the holder of the office of presidency, in which category the third respondent falls. Furthermore, we note that Section 14.3 of the Election Offences Act, which provides for the Commission's enforcement powers, does not apply to the person holding the office of president. The section we have quoted there in verbatim. Having that in mind and fortified by our observation that the interpretation of Section 14 of the Election Offences Act is a live matter before the High Court, we are unable to address our minds into an allegation that touches on this section. That is the end of that allegation. We are unable to deal with that in the absence of any evidence. We further note in paragraph 34 of his said affidavit that Raila also claimed that while campaigning in Makueni County, on 2nd August 2017, President Uhuru Kenyatta threatened chiefs in the area with dire consequences if he won for failure to campaign for him. That such an action also goes against Article 81E2 of the Constitution, which outlaws intimidation in the electioneering process. In proof of this assertion, the petitioners have attached transcripts of video evidence in the supplementary affidavit sworn by Ogila Karani, detailing the alleged offending words spoken by the third respondent. In response, the third respondent relies on an affidavit sworn by Dr. Karanja Kibicho, who affirms that the Principal Secretary, Ministry of Interior and the Coordination of National Government, he received information to the effect that some chiefs in Makueni, whose names also were provided in the said affidavit, were unlawfully using their positions and the government issued motorcycles to campaign for the petitioners. He therefore reported the same to the third respondent, who warned the chiefs in that area not to take any political position nor use public resources to campaign for anyone. According to Dr. Kibicho, it is against that background that the third respondent uttered the words, uttered the remarks now banned by the petitioners. In the above context, Section 10 of the Election Offences Act is also relevant. We have quoted the full section. What then is the meaning of undue influence in the context of electoral malpractices, and particularly as used under Section 10 above? In India, the meaning of undue influence is found in Section 171C of the Penal Code, which defines the offense of undue influence in that country. Though the wording of the Indian Penal Code quoted above is materially different from Section 10 of the Elections Act, the meaning injected into the above legal provision shows its applicability to the Kenyan context. The Supreme Court of India, in the consolidated case of Charan Lal versus Gilani and others, thus explicitly stated that the test was whether there was an interference or an attempted interference with the free exercise of the electoral right. Similarly, Section 10 above, whose marginal note is undue influence, forbids any impediment of a person's exercise of the electoral right. In India, the electoral right of an elector is defined under Section 171AB of the Indian Penal Code as the right of a person to stand or not to stand, or to withdraw from being a candidate, or to vote or refrain from voting at an election. This is comparable with the Article 38(3) of our Constitution, which confers certain political rights on every citizen without any restrictions, including the right to vote by a secret ballot in an election. The above case of India laid down distinction between mere canvassing for votes and the acts of undue influence. In so doing, the Supreme Court of India pronounced itself in the following manner, and I quote, "If the mere act of canvassing in favor of one candidate as against another were to amount to undue influence, the very process of democratic election shall have been stifled, because the right to canvass support for a candidate is as much important as the right to vote for a candidate of one's choice. Therefore, in order that the offense of undue influence can be said to have been made out within the meaning of Section 171C of the Penal Code, something more than the mere act of canvassing for a candidate must be shown to have been done by the offender. That something more may, for example, be in the nature of a threat, of an injury to a candidate or a voter, as is stated in the subsection 2A of Section 171C of the Penal Code, or may consist of inducing a belief of divine displeasure in the mind of a candidate or a voter, as is stated in subsection 2. The act allegedly as constituting undue influence must be in the nature of pressure or tyranny on the mind of the candidate or the voter. It is not possible to enumerate exhaustively the diverse categories of acts which fall within the definition of undue influence. It is enough for our purpose to say that of one thing there can be no doubt: the mere act of canvassing for a candidate cannot amount to undue influence within the meaning of Section 171C 1C of the Penal Code, end of quote. The Supreme Court of India also held that the language used in the definition of undue influence implies that an offense of undue influence will be held to have been committed if the elector, having made up his mind to cast a vote for a particular candidate, does not do so because of the act of the offender. And this can only be if he is under the threat or fear of some adverse consequences. Wherever any threat of adverse consequences is given, it will tend to divert the elector from freely exercising his electoral right by voting for the candidate chosen by him for the purpose. But in cases where the only act done is for the purpose of convincing the voter that a particular candidate is not the proper candidate to whom the vote should be given, that act cannot be held to be one which interferes with the free exercise of the electoral right, end of quote. The test of undue influence is therefore whether the third respondent's conduct, if satisfactorily proved, created in the impression, an impression in the mind of a voter that adverse consequences would follow as a result of their exercise of their political choices. In applying that test, we cannot, however, ignore the disposition of Dr. Kibicho, who impugned the allegation, the alleged non-impartiality on the part of the two chiefs, who are public servants. Thus, the third respondent's statement above must also be tested against the testimony of Dr. Kibicho, which evidence has not been controverted. In the above context, therefore, as a case been made out against the third respondent for the commission of the offense of undue influence within the required standard of proof, have the petitioners dispelled the third respondent's position that he was merely giving a directive that it was against the law for a public officer to openly take political positions in support of one candidate against the other? In this context, words alone, without any other demonstrable evidence, are not sufficient to enable this court to make conclusive finding on this issue. Further, we note that from the evidence of Dr. Kibicho explaining the context within which the third respondent uttered the said words remain undisputed. Consequently, after carefully considering the evidence before us, we hold that the petitioners have not proved their case on this issue as required, the required standard. The petitioners further alleged that the third respondent and the deputy president, being contestants in the presidential election, are guilty of corruptly influencing voters in the lead up to the 8th August 2017 general election by paying reparations to victims of 2007 post-election violence in various parts of the country, and used the platform to canvass for votes for personal political gain in the said electoral areas, contrary to the Election Offences Act. In proof of this assertion, the petitioners rely on the affidavit of Ms. Ogla Karani, who attaches a transcription of the third respondent's speech during his tour of Kisii and Nyamira counties during the campaign period. In response, the third respondent relied on the affidavit sworn by Dr. Kibicho, aforesaid, who stated that there is a National Consultative Coordination Committee which is tasked with the obligation to manage the internally displaced persons' affairs on behalf of the government. That any such sums are approved by Parliament and released by the committee into the beneficiary's account, and the third respondent is not involved in that matter at all. We have perused the attached video transcript, which is the form of interview conducted by one of the local news reporting station, we note that the transcript does not contain a satisfactory basis or convincing evidence to the effect that the third respondent acted in any inappropriate manner with regard to the release of the funds for the IDPs. The first petitioner's further complaint on illegalities is that the President Uhuru Kenyatta engaged cabinet secretaries who openly abused their position and used state resources in actively soliciting votes for him. Referring to Article 152(4)(a) of the Constitution, the petitioner submitted that that every cabinet secretary swears to or affirms to have obedience to the Constitution of Kenya and ought therefore to be impartial in political contests as is required under the Constitution. In a supplementary affidavit sworn by Olga Karani, the petitioners list various incidences in which they claim that the cabinet secretaries campaigned for the third respondent. At paragraph 10 of the said affidavit, the deponent affirms that Joe Mucheru, the cabinet secretary in charge of information, communication and technology, at an interview conducted by a local television station, he stated that he was at liberty to campaign for the third respondent because no law barred him from doing so. Other cabinet secretaries also mentioned in Karani's affidavit include Eugene Wamarwa, Mwangi Kiunjuri, and Najib Balala. The petitioners in their submissions on these issues brought to the attention of the court what they consider to be an inconsistency in the law, and in this respect, they urged the court to declare Section 23 of the Leadership and Integrity Act to be unconstitutional. In that regard, we have quoted the full section. The petitioner submitted that since cabinet secretaries are state officers, they ought to be impartial, but that Section 23 above gives them leeway for impartiality. The third respondent contested that submission and urges the court to disregard it, since the issue of unconstitutionality was not pleaded in the petition, but was only introduced as an argument in the petitioner's oral submissions. The third respondent also urges that the Supreme Court, in exercise of its exclusive original jurisdiction, cannot adjudicate on the unconstitutionality of an act of Parliament, since that is a matter within the domain of the High Court in exercise of its jurisdiction under Article 165(3)(d) of the Constitution. In addressing the above issue, we note that in rendering our advisory opinion, we also say that we cannot deal with a matter. No, I will read that again. In addressing the above issue, we note that in rendering an advisory opinion in the matter of the Interim Independent Electoral Commission, this court stated at paragraph 43, and I quote, "Quite clearly the High Court has been entrusted with the mandate to interpret the Constitution. This empowerment by itself, however, does not confer upon the High Court an exclusive jurisdiction, for by the appellate process, both the Court of Appeal and the Supreme Court are equally empowered to interpret the Constitution, certainly in respect of matters resolved at the first instance by the High Court. And while the advisory opinion jurisdiction is exclusively entrusted to the Supreme Court, the Constitution does not provide that this court, while rendering an opinion, may not interpret the Constitution. Indeed, interpretation of the Constitution stands to be conducted for different purposes and at different stages by a vast array of constitutional organs. So, for instance, the State Law Office, in advising government ministries, is entitled to interpret the Constitution as may be necessary, and the several independent commissions under the Constitution are similarly entitled to interpret the Constitution as part of the performance of their respective mandates. The Supreme Court, too, for purposes of rendering an advisory opinion, may take its position as guided by its own interpretation of the Constitution. Only where litigation takes place entailing issues of constitutional interpretation must the matter come in the first place before the High Court, with the effect that interpretation of the Constitution by both the Court of Appeal and the Supreme Court will have been limited to the appellate process. End of quote. It is not in doubt, therefore, that the Supreme Court may, in exercise of its jurisdiction, such as this, interpret the Constitution, and in so doing, where the need requires, declare an offending provision of the law to be unconstitutional. Such is a natural consequence of any legal reasoning if the court were to maintain its fidelity to the law. Indeed, in the case of SK Macharia versus KCB, the court declared Section 14 of the Supreme Court Act to be unconstitutional. However, the present scenario is peculiar in the sense that the petitioners did not, at the very first instance, through their pleadings, indicate their intentions to declare Section 23 of the Section 23 unconstitutional. The rule of thumb has always been that parties must be bound by their pleadings, and especially in a case such as this, where the petitioner is asking the court to address its mind to the possible unconstitutionality of a legal provision. For proper consideration, therefore, and especially in order to do justice to both the parties and the greater public interest, we cannot afford to lock our eyes to the disadvantage placed upon the third respondent, especially who had no benefit to bring his mind, to bring his thoughts into this course. In the circumstances, we are unable to find that Section 23 is unconstitutional. Let the matter be addressed in the right proceedings, in the right circumstances. Irregularities. Apart from the outright non-compliance with the electoral law, the petitioners also claimed that the presidential election was marred by many irregularities, and the cumulative effect of which fundamentally and negatively impacted on the integrity of the election. The most serious of the irregularities alleged by the petitioners was that many of the prescribed forms 34A, 34B, and 34C that were used in the election had no security features. Other such forms had different layouts and security features. I don't have to read all that. We have considered the security features. The prominent one coming out of this is that some of these forms did not have those security features, whereas the information we were given was that they were all printed by the same printer and they should have had those security features. We disagree with the council that this is not in the Act and that it was as a result of abundance of caution taken by IEBC. If that was the case, then all the forms should have the features, the security features that IEBC itself devised, and there is no reasonable explanation given why some should not have and some should have. That is the conclusion we have reached. So we have also considered that there are some, the report which was tabled, the scrutiny report, shows that some forms that were availed were carbon copies, others were the original forms 34A, but did not bear those, the IBC stamp. Other forms were stamped and scanned, while others were not, and they were photocopies. We have considered all those, the report that was availed, but what comes out is that from the report, the scrutiny report indicates that out of a random examination of 4,299 forms 34A, 481 were carbon copies, but they were signed. 157 were carbon copies which were not stamped. 269 were original copies that were not signed. 26 of the forms were stamped. And some were not signed by the agents as required, and there was no explanation given as to why the agents did not sign, or they were, why they were not given to sign. Submitting on these findings, Mr. Orengo, for the petitioners, contended that the report had proved beyond reasonable doubt that the election process was shambolic. According to counsel, from 34C, which was used to announce the presidential results, had no security features, and hence the authenticity of the results, as announced in Form 34C, could not be guaranteed. Counsel further contended that in totality, the number of votes affected is more than 90 constituencies. In more than 90 constituencies, as a consequence of these irregularities, could be as high as 5 million. Counsel submitted that a random sampling of the Forms 34A depicts numerous irregularities, those ones which I have already enumerated. In response, the respondents were categorical that most of the forms met the standard required features. They stated that the petitioners had failed to demonstrate that any of the figures in the forms were inconsistent with what was announced. Further, that the format of the forms was undisturbed. I'm trying to skip the parts which are details of which I've explained. As we have noted that out of 291 forms, 56 from that random sample, 56 did not have the watermark features, while that one did not bear the serial numbers. And a further 5 were not signed at all. And the 2 were only stamped by the returning officers, but not, were stamped by the returning officers, but not signed. In addition, a further 32 forms were not signed by the agents. The above indices are a single out, since they are indices where accountability and transparency of the forms are in question. The court also notes that in her affidavit, Immaculate Kasaiti, director of the first respondent, stated, and we have quoted in extenso the averments of Kasaiti, where she categorically states that all these forms had the features that were given by IEBC to the printers. The above categorical statement differs completely with the abundance of caution submission by Mr. Muite, Senior Counsel, that it is not in the law and this was just optional for IBC to make. In the above context, we now turn to examine the applicable statutory provisions in this regard. As pointed out by the petitioners, there is a reasonable expectation that all forms ought to be in a standard form and format, and though there is no specific provision requiring the forms to have watermarks and serial numbers as security features, there is no plausible explanation for this discrepancy, more so when Immaculate Kasaiti deposed that all of them had those features. There is another set of discrepancies relating to 31 forms not being signed by the agents, 103 forms where the handover report was not signed against the regulations that require that. It is clear that the purpose of including the requirements for indicating the number of forms received by various officers was to ensure accountability and transparency. It is therefore unfortunate that out of the random sample of 4,299 forms that 4A examined, a total of 189 forms had not been filled in the handover section, whereas 287 forms had not been filled in the takeover section. Such a kinds of scenarios raises the question as to the kind of verification done, if at all, by the chairperson of the commission. As Forms 34A, the sampled 4,299 forms revealed that 481 of them were carbon copies, 269 were not stamped, 257 of the carbon copies were not signed, 11 forms had no watermarks, 46 of the photocopies were not signed, and 58 others not stamped. Considering the sample size, it is apparent that the discrepancies were widespread. Did these discrepancies affect the integrity of the elections? I now consider the impact of the irregularities on the integrity of the election. Counsel for the respondents urged the court to dismiss the petition, as this would preserve the will of the people who turned out in large numbers to vote for their preferred candidates. Our attention in that regard was drawn to the provisions of Article 38 of the Constitution, which is the embodiment of the political rights of the citizen. It was variously submitted that the elections are about numbers and that they are about who gets the largest number of votes. Such irregularities, as complained of by the petitioners, counsel submitted, could not in themselves overturn the sovereign will of the people. Further, in the quantitative discrepancies, if the quantitative discrepancies are so negligible, in this case, allegedly slightly over 20,000 votes, they should not affect the election. For in the words of Professor Lumumba, counsel for the second respondent, of small things, the law has no remedy. On the other hand, the counsel for the petitioners urged the court to look at the elections as a whole, as a process rather than an event, to look at not just the numbers, but the entire conduct of the election. Mr. Mwangi, counsel for the petitioners, went as far as to submit that the elections are not political processes. I'll read that again. Mr. Mwangi, counsel for the petitioners, went as far as to submit that the elections are not a political process, but a legal one. That the court should concentrate on examining the legal process in the conduct of elections as opposed to the political process. It is our view, however, that elections are all these. None of the factors highlighted by the parties can be viewed in isolation. For by doing so, we run the risk of cannibalizing a sovereign process. Elections are the surest way through which people express their sovereignty. Our Constitution is founded upon the immutable principle of the sovereign will of the people. The fact that it is the people and they alone in whom all power resides, be moral, political, or legal, and so they exercise such a power either directly or through representatives whom they democratically elect in free, fair, transparent, and credible elections. Therefore, whether it be about numbers, whether it be about laws, whether it be about processes, an election must at the end of the day be a true reflection of the will of the people as decreed by the Constitution through its hallowed principles of transparency, credibility, verifiability, accountability, accuracy, and efficiency. It is in this spirit that one must read Article 38 of the Constitution, for it provides in the area that every citizen is free to make political choices which include the right to free, fair, and regular elections based on a universal suffrage and the free expression of the will of the electors. This mother principle must be read and applied together with Articles 81 and 86 of the Constitution. For to read Article 38 in a vacuum and disregard other enabling principles, laws, and practices attendant to elections is to nurture a mirage and an illusion of free will, hence a stillborn democracy. Of such an enterprise, this court must be wary. It is also against this background that we consider the impact of irregularities that characterize the presidential election. At the outset, we must re-emphasize the fact that not every irregularity, not every infraction of the law is enough to nullify an election. Were it to be so, there would be hardly an election in this country, if not in the world, that would withstand judicial scrutiny. The correct approach, therefore, is for a court of law to not only determine whether the election was characterized by irregularities, but whether those irregularities were of such a nature or of such a magnitude as to have either affected the result of the election or to have negatively impacted the integrity of the election, that no reasonable tribunal would uphold it. In view of the interpretation of Section 83 of the Elections Act that we have rendered, this inquiry about the effect of electoral irregularities and malpractices becomes only necessary where an election court has concluded that non-compliance with the law relating to the election did not offend the principles laid down in the Constitution or in that law. But even where a court has concluded that the election was not conducted in accordance with the principles laid down in the Constitution and the applicable electoral laws, it is good judicial practice for the court to still inquire into the potential effect of any irregularities that may have been noted upon an election. This helps to put the agencies charged with the responsibility of conducting elections on notice. In the impending presidential election, one of the most glaring irregularities that came to the fore was the deployment by the first respondent of prescribed forms that either lacked or had different security features. The first respondent had submitted by way of affidavit and in open court that out of abundance of caution, it had embedded into the prescribed form such impenetrable security features that it was nigh impossible for anyone to tamper with them. The court was also minded that this was done despite being not a requirement of the law. However, the scrutiny order and the scrutiny ordered and conducted by the court brought to the fore momentous disclosures. What is this court, for example, to make of the fact that 290 out of 290 Forms 34B that were used to declare the final results, 56 of them had no security features. What had the security features touted by the first respondent disappeared to? Where had they disappeared to? Could these critical documents be still considered genuine? If not, then could they have been forgeries introduced in the vote tabulation process? If so, with what impact do the numbers if they were forgeries, who introduced them into the system? If they were genuine, why were they different from the others? We were disturbed by the fact that after an investment of taxpayers' money running into billions of shillings for the printing of election materials, the court would be left to ask itself basic fundamental questions regarding the security of voter tabulation forms. Form 34C, which was the instrument in which the final result was recorded and declared by the public, was itself not free from doubts of authenticity. This form, as crucial as it was, bore neither watermark nor serial number. It was instead certified as being a true copy of the original. Of the 4,229 forms 34A that was scrutinized, many were not stamped, yet others were not signed. I think that I've already stated that. Why would a returning officer, or for that matter the presiding officer, fail to or neglect to append his signature to a document whose contents he or she generated? Isn't the appending of the signature to form a bearing that the tabulated results, the last solemn act of assurance to the voter by such an officer that stands by the numbers on the form? Where do all these inexplicable irregularities that go to the very heart of electoral integrity leave this election? It is true that where the quantitative difference in numbers is negligible, the court, as we were urged, should not disturb the election. But what if the numbers are themselves a product not of the expression of the free and the sovereign will of the people, but of many unanswered questions with which we are faced? In such a critical process as the election of the president, isn't quality just as important as quantity? In the face of all these troubling questions, would this court, even in the absence of a finding of violations of the Constitution and the law, have confidence to lend legitimacy to this election? Would an election observer, having given clean bill of health to this election on the basis of what he or she saw on the voting day, stand by his or her verdict when confronted with these imponderables? It is to the Kenyan voter that a man or woman who wakes up at 3 a.m. on voting day, carrying with him or her the promise of the Constitution to brave the vicissitudes of nature in order to cast his or her vote, that we must leave that judgment. In concluding this aspect of the petition, it is our finding that the illegalities and the irregularities committed by the first respondent were of such a substantial nature that no court, properly applying its mind to the evidence and the law as well as the administrative arrangements put in place by IEBC, can in good conscience declare that they do not matter and that the will of the people was expressed nonetheless. We have shown in this judgment that our electoral law was amended to ensure that in substance and form, the electoral process and the results are simple yet accurate and verifiable. The presidential election of 8 August 2017 did not meet the simple test, and we are unable to validate it, the results notwithstanding. I'm skipping the orders that have been sought. In conclusion, in this judgment, we have settled the law as regards Section 83 of the Elections Act and its applicability to the presidential election. We have shown that, contrary to the popular view, the results of an election in terms of numbers can be overturned if a petitioner can prove that the election was not conducted in compliance with the principles laid down in the Constitution and the applicable electoral law. Never was the word "or" been given such a powerful meaning. Why did we do this? We did so because that's the word "or" in Section 83 of the Elections Act. We did it so because, as judges, we have taken an oath as advocates first and as judges later. In these two oaths, the fundamental words are a fidelity to the Constitution without fear or favor. The constitutional principles that we have upheld in this judgment were embedded and became a critical part of our electoral law. The legislature, in its wisdom, chose the words in Section 83 of the Elections Act, and in keeping to our oath, we cannot, to placate any side of the political divide, alter, amend, read into or in any way affect the meaning to be attributed to that section. As for the IEBC, all we are saying is that the constitutional mandate placed upon it is a heavy yet noble one. In conducting the fresh election consequent upon our orders, and indeed in conducting any future election, IEBC must do so in conformity with the Constitution and the law. For what is the need of having a constitution if it is not respected? Having taken note of Mr. Nyamudi's submissions, which appeared to suggest that IEBC had put in place a complementary system for transmission of results, a system that was neither simple nor known to the petitioners, we hereby direct that in conducting the fresh election, IEBC must put in place a complementary system that accords with the provisions of Section 44A of the Elections Act. It goes without saying that such a system, as held by the High Court and affirmed by the Court of Appeal in the case of National Super Alliance versus Independent Electoral Commission, only comes into play when the technology fails. In the 2013 Raila Odinga case, the court stated, and I quote, "It should not be for the court to determine who comes to occupy the presidential office, save that this court, as the ultimate judicial forum entrusted under the Supreme Court Act, with the obligation to assert the supremacy of the Constitution and the sovereignty of the people of Kenya, must safeguard the electoral process and ensure that the individuals accede to the power in the presidential office only in compliance with the law regarding the elections." We reiterate those words in this petition, and for as long as the Constitution of Kenya has the provisions granting this court the mandate to overturn a presidential election in appropriate circumstances, it will do so because the people of Kenya, in the preamble to the Constitution adopted, enacted and gave unto themselves the Constitution, and for themselves and the future generations. It is also our view that the greatness of a nation lies not in the mighty of its armies, important as that may be, not in the largeness of its economy, important as that may also be. The greatness of a nation lies in its fidelity to the Constitution and the strict adherence to the rule of law, and above all, the fear of God. The rule of law ensures that society is governed on the basis of the rules and not the mighty of force. It provides a framework for orderly and objective relations between citizens in a country. In Kenya, in the Kenyan context, this is underpinned in the Constitution. And as Surabaj, a former Attorney General of India, wrote, "The rule of law is the heritage of all mankind, and a salutary reminder that wherever law ends, a tyranny begins. Cast the rule of law to the dogs, and as Lawton once observed, the government becomes an euphemistic government of men. He adds, history has shown, sadly I might add, that even the best rulers have fallen prey to the cruel desires of naked power, and that reliance on the goodwill of politicians is often a risky act of good faith, end of the quote. The moment we ignore our constitution that the Kenyans fought for decades, we lose it. We further note that elections world over are competitive features. Presidents in many parts of the world, and especially in Africa, wield a lot of power. The influence that comes with that office makes it very attractive. That influence cascades down through all the elective positions to the lowest. Candidates and political parties often do anything to be elected. Besides the candidates, the electorate themselves, hoping for an improved standard of living, get equally agitated. All these factors make elections at every level extremely high-pressure events. If these are mismanaged, or candidates do not respect the rule of law, if the average citizen, political parties, and even candidates themselves do not perceive them as free and fair, elections can and have led to instability in some countries. Examples of such cases are abound, but we don't need to look far. We know what we went through in 2007, post-election skirmishes that left over 1,000 people dead and over 5,000 others displaced and drove the country almost to the brink of precipice, not to mention the economic crisis that was thereby wrought. In the circumstances, and in answer to the respondents' harp on the numbers, we can do no better than to quote the words of the Indian Court of Appeal, where the judge says, there is no denying the fact that the election of a successful candidate is not likely to be interfered with by the courts. The courts generally lean in favor of the returned candidate and place the onus of proof on the person challenging the end result of an electoral contest. That approach is more in the nature of a rule of practice than a rule of law, and should not be unduly stretched beyond a limit. We say so because while it is important to respect the popular verdict and the courts ought to be slow in upsetting the same, it is equally important to maintain the purity of the electoral process. An election which is vitiated by reason of corrupt practices, illegalities, and irregularities cannot obviously be recognized and respected as the decision of the majority of the electorate. The courts are, therefore, duty-bound to examine the allegations wherever the same are raised within the framework of the statute, without being unduly hyper-technical in its approach, and without being oblivious to the ground realities. Experience has shown that the electoral process is, despite several safeguards taken by the statutory authorities concerned, often vitiated by use of means, factors, and considerations that are specifically forbidden by the law. What of the argument that this court should not subvert the will of the people? This court is one of those to whom the sovereign power has been delegated under Article 1(3)(c) of the Constitution. All its power, including the invalidating of the presidential election, is not self-given nor forcibly taken, but is donated by the people of Kenya. To dishonestly exercise that delegated power and to close our eyes to the constitutional violations would be a dereliction of duty, and we refuse to accept the invitation to do so, however popular the invitation may seem. Therefore, however burdensome, but the majesty of the Constitution reverberates across the lengths and breadths of our motherland. Let it bubble from our rivers and oceans. Let it boomerang from our hills and mountains. Let it serenade our households from the treetops. Let it sprout from our institutions of learning. Let it toll from our sanctrums of prayer. And to those we bear the responsibility of leadership, let it be a constant irritant. Have we, in executing our mandate, lowered the threshold for proof in presidential elections? Have we made it easy to overturn the popular will of the people? We do not think so. No election is perfect, and the technology is not perfect either. However, where there is a context in which two houses of parliament jointly prepare a technological roadmap for conduct of elections and insert a clear and simple technological process in Section 39(1)(c) of the Elections Act, with the sole aim of ensuring a verifiable transmission and a declaration of the result system, how can this court close its eyes to an obvious and near total negation of the transparent process? In keeping with our pronouncement regarding the burden and the standard of proof in election petitions, we are therefore satisfied that the petitioners have discharged the legal burden of proof as to squarely shift it to the first and second respondent. We are also of the firm view that having so shifted the burden has not in turn been discharged by the first and second respondents as to raise substantial doubt in regard to the petitioner's case. For the above reasons, let this judgment then be read in the proper context. The electoral system in Kenya today was designed to be simple and verifiable. Between the 8th of August 2017 and the 11th of August 2017, it cannot be said to have been so. The petition before us was, however, simple and to the point. It was obvious to us that IEBC misunderstood it, hence it jumbled up responses and submissions. Our judgment is also simple and, in our view, clear and understandable. It ought to lead IEBC to a soul searching and to go back to the drawing board. If not, this court, wherever called upon to adjudicate on a similar dispute, will reach the same decision if the anomalies remain the same, irrespective of who the aspirants may be. Consistency and fidelity to the Constitution is an unwavering commitment this court makes. One of the other peripheral but important matter requires our attention: the time frame for hearing and the determination of presidential election petition in Kenya. The court is able to bear all manner of criticism, but one would be extremely unfair. Alleged inability to deliver on time. Where is the time? Between the decision in 2013 and the present petition, it was a matter of agreement across Kenya that 14 days is not enough for parties and the court to fully deliver on their respective mandates. Not because they cannot, in fact they all have, but because there may be the need to conduct exercises such as a recount of votes or a scrutiny which require substantial amount of time. Yet the legislature ignored pleas to rethink the time frame. It is time they did so. The reasons for doing so are obvious and need no extrapolation here. In concluding, we must express our profound gratitude to Council who appeared before us for their submissions that assisted us in reaching this decision. Before we read the final orders, I would now allow my colleagues to read their dissents. And I'm requested to start with Justice Ojwang.